Hello again. Whoa. I can project pretty well, so I feel like I'm really projecting right now. Again, welcome. My name's Andrew Bossy. I'm the Executive Director of Maine Citizens for Clean Elections until the end of this month. We work to ensure that the voices of everyday people are heard and heeded in our elections and government so we can have a government that's more truly of, by, and for the people. Thank you for being here today for this exciting talk. I want to thank in advance our panelists, Jill Ward, Anna Keller, our moderator, John Brautigam, who I'll introduce in a second, and of course, Seth Waxman for coming all the way up to Maine. I also want to thank again the Board of Maine Citizens for Clean Elections and the staff. And I also want to make a special shout out to our presenting sponsors for today's event. American Promise, Drummond Woodsum, our lobbying firm, Howe & Cahill, they're the good lobbyists, the new media firm, and last but not least, the League of Women Voters of Maine Education Fund. Some of you also provided financial help by joining our host committee, so thank you very much for doing that. And then finally, I want to thank each and every single one of you, the Maine Citizens for Clean Elections. Maine has led this country because of your excellent work. In the 6 years I've been here, I've had the distinct pleasure to actually spread the word of clean elections to other parts of the country. And I was in Arizona maybe 2 years ago now, and a board member for an organization there by the name of Mike Vlader asked me to describe myself at 13 years old. He said, I found that that's the easiest way to actually get to know someone, substance behind someone. So I grew up in rural northern Maine, Caribou, a pretty much poor family in a poor community. I was gay, it's Pride Week, so I feel like compelled to say that. And I had family challenges, but it was a social safety net that literally saved my life. Teachers and a strong education system, DHHS, public safety, and those types of opportunities that really allow me to be literally living the dream that I'm living today. But as I moved into adulthood from the 13-year-old me that sat there wanting a better future for me and my family, I then started to say, I need to create that future. I need to be one of the people that actually creates that better tomorrow we're always talking about. So I set off on improving the cost of higher education. I worked on LGBT non-discrimination and eventually marriage. I also worked for healthcare reform. And in each of those, I saw that there was a certain group of people that got more say than others, than the people that were disenfranchised in those areas. So 13 years later, at the age of 26, I came to understand that money in politics is distorting our representative democracy. And I came to the solution that if I want to actually make progress on any of those issues, that we have to go to the root of what's happening. Benjamin Franklin once said, there's 1 million people hacking at the branches of evil for every one striking at its root. And what we do here at Maine Citizens for Clean Elections is strike at the root of our democracy, to strengthen and nourish that tree that provides for all of us to have that fair, just, and equitable future we all deserve. So democracy is a process by which we ensure that everyone is at the table and that we ensure that their voices are heard. And so now, after 6 years at Maine Citizens for Clean Elections, I'm so proud of what we've accomplished. We fought back against wrong-headed Supreme Court rulings. We fought for disclosure and transparency in our elections, accountability to make sure people follow our rules and laws, and we fought for more voice and more choice through other reforms like ranked choice voting. It was when I was 13 years old, though, there were a group of people preparing to go to the ballot here in Maine to lead Maine citizens in their first-in-the-nation effort to have a full system of public financing. So I was 13 in 1996 when Maine voters overwhelmingly went to the polls to approve that law, first in the nation, done by everyday Maine people collecting signatures and knocking on doors and making phone calls. We didn't use email as much back then, but contacting everyday people and and rolling up our sleeves and using that Yankee ingenuity to find creative solutions to our problems and then doing something about it. One of those people was John Brautigam. John is an attorney and a consultant for over 25 years in Maine and has experience in campaign finance and election law. In fact, I often say there's no one in the state that knows Maine's election law better than John Brautigam, and I don't say that to be flattering, I think it's actually true. From 2004 to 2008, John served in the Maine legislature representing the people of Falmouth. His tenure in the legislature led him to be the chair of the Insurance and Financial Services Committee. And then prior to that, he served as legal counsel for the 1996 referendum that we talked about and making sure that the laws that Maine people passed stayed strong by defending them in courts. John holds a degree from Stanford Law, and he was appointed executive editor, almost there, to the Stanford Law Review. It's kind of a metaphor right now that I'm about to introduce John to be up to the stage, because John is actually taking the interim executive director role title while the board and the staff work to create a vision for the next few years. And it's with great honor, and it makes me sleep a lot better at night knowing that I can continue to support this work in a different and evolving role, knowing that John and Anna are going to be here, Anna Keller, our program director, doing this work that's based on all of what you're doing. So without further ado, I'd like to introduce our moderator for this afternoon's talk, John Brautigam.
Thank you, Andy, for all those nice comments. I wish my mom and dad were here to have heard that. My dad would have really been tickled, and my mom would have actually believed it. My role right now is a real honor, and is to introduce our featured guest and speaker today. You've all, even those of you who haven't been to law school or really been deeply involved in the law or legal history, know of John Adams, John Marshall, titans of the legal world like Clarence Darrow and Thurgood Marshall. To that list after today, I hope you will add the name of Seth Waxman. And that's without exaggeration. As an attorney coming of age in the last 25 years professionally, Seth Waxman has been the go-to appellate and trial attorney in this country for many, many very important causes and organizations and purposes that we all could share and are all behind. So it's a real pleasure to have him here today. A little bit of biographical background. He was the chief courtroom lawyer for the United States Department of Justice from 1997 to 2001, position called the Solicitor General. He has a list of professional awards and accolades that would take us all afternoon to go through, so I won't touch on those, but I will say I'm impressed to know that he is very involved in the community, in community organizations, educational organizations. He's been very involved, active in committees of the American Bar Association. He's been a partner and a leader of the litigation group at WilmerHale law firm, one of the premier law firms in the world for the last 16 years. And as you know, he was the lead attorney on the Citizens United case, which we're going to hear a little bit more about here shortly. One of the favorite things I found in doing just a little bit of background to prepare for this introduction was an article that described him as an indefatigable idealist. And I think that is what we need, and we've already been talking about the purpose and need for optimism and idealism going forward, and it's really a pleasure to have a person who embodies that here today. Finally, I think Seth Waxman would make a terrific Supreme Court justice. And I hope you'll agree after you hear his comments today and the rest of our panel. So without further ado, Seth Waxman.
John, is this your water or is this more water for me? That's not mine. So. Andy's? It's me. Great. Terrific. Okay, well, thank you all very much. And thank you, John, for the introduction. sometimes I have to, I guess even indefatigable idealists sometimes need a little bucking up. And, you know, I know when I was first invited a couple of years ago by this group to come up and talk, and really at the time, I think most of you were here when I gave my remarks just outside here, maybe all of you were here. You know, having worked on campaign finance reform starting in 1998 and leading up to passage of the bipartisan Campaign Reform Act and defending that in McConnell versus FEC in the Supreme Court, and then watching things slide downhill, it's taken me a couple of years to be able to re-engage with campaign finance reform. There was a period, say from about a year ago, when Justice Scalia passed away and Merrick Garland was nominated to replace him, that the folks here at MCCE and I and other similar groups around the country were talking very concretely and progressively about how, on a bipartisan basis, to advance, you know, democracy and you know, perhaps make the Supreme Court's decision in Citizens United an irrelevant relic of the past. I think, in large part, what happened to Merrick and what happened in the election made me realize that, okay, it's time to stop running away from the Supreme Court's, what I view as a very regrettable line of decisions, and to re-engage on this particular issue. So, you know, Andy talked about, you know, his coming out, and this event is my coming back to campaign finance reform as a major priority for me. I mean, I do think it's no exaggeration to say that, you know, whether it's establishing, reestablishing, or restoring, whatever gerund you want, our democracy and the vitality of democratic governance in the United States is the urgent priority of the day. And what I mean about that is ensuring that people who are eligible to register and vote can readily do so, using systems that are secure, which I'll talk about a little bit later on, that voting districts are drawn in a nonpartisan, discriminatory way so that the end result in the general election is not a foregone conclusion, which it is in over 90% of the U.S. congressional districts today, and that campaign finance and disclosure laws maximize the chance that officials who are elected to be our representatives are in fact responsive to the people who elected them and not to others. Now, as I see it, looking out in mid-2017, there are essentially 4 areas of concern and opportunity. First is campaign finance, which is an issue that has brought so many of us here today. The next is districting. The next is access to voting. And the final is voting security. And I'll just offer a few remarks, you know, on each of them. I have to say that I have a well-recognized and certainly by members of my family, well-documented poor record at self-restraint when I'm standing at a podium without a red light. You know, in the Supreme Court, there's like green light, a white light, and a red light. And they put the white light on with 5 minutes to go, which is, you know, an indication that, and when the red light comes on, you actually have to stop talking. It's not just some decoration that is, you know, a suggestion from the justices that you might want to start bringing things to a coalesced conclusion. It's like the red light is on, you're done. And without one, I have a little bit of a hard time regulating myself, but I've been assured that John, that the main event today should be questions and answers and engaging in a dialogue with all of you and with my other panel members. So John has volunteered to to clear his throat 3 times and then stand up and start proceeding to the stage somewhere between 20 and 30 minutes, and then I'll stop and we can go to the questions and answers. So, money in politics. The degree of popular support across the United States, across party affiliations, across urban and rural areas for regulation of money in politics is about as overwhelming as you get on any issue in the United States. I mean, the percentage of Americans who, when polled, say that either they oppose Citizens United or they oppose dark money in politics, they oppose the ability of wealthy people and business trusts and corporations making outsized either political contributions or expenditures is north of 80%, which is pretty extraordinary because, I mean, in a country as diverse as ours, where people's attentions and priorities are pressed in so many different directions, and so many people are basically, their number one priority is just trying to make ends meet. To have between 80 and 90% of the population saying, we feel strongly about this, is amazing. And what makes it particularly amazing is how unresponsive our elected representatives, and in particular our unelected judges, are to this demand. The Supreme Court, starting, as I said, when Justice O'Connor left the court, starting in a case that I argued in law called Wisconsin Right to Life, and then Citizens United and McCutcheon and several other cases, has been essentially stripping away, large parts of the provisions of the Bipartisan Campaign Reform Act, and also declaring as a constitutional matter areas of campaign finance reform, as difficult as they always are to get through legislators, constitutionally off the map. There are a couple of exceptions, and it's important that all of us that are interested in persevering and creating a more perfect union focus our attention on, that the Supreme Court has not foreclosed. One of them is actual contribution limits as opposed to expenditures. That is, the amount of money that individuals can contribute to a particular candidate in an election cycle. The prohibition, the continued prohibition on labor unions and corporations from making direct contributions to candidates is still on the books, and still is a viable and fruitful avenue for state legislation on a state-by-state basis. The prohibition against what is referred to as soft money, which is, unregulated contributions or donations to state and local political parties, which prior to 1996, to the Bipartisan Campaign Reform Act, or 2002, was unregulated. So there was a limit on how much you could contribute, for example, to the National Democratic Party or the National Republican Party, but no limit on the amount you could contribute to the Maine Democratic Party, the Massachusetts Democratic Party, the Alaska Democratic Party, and those parties, although ostensibly they were raising money for state elections, were overwhelmingly using that money to promote federal candidates. And Congress shut that loophole, and it has thus far remained shut. The Supreme Court, just a couple weeks ago, denied review in a case brought by the Louisiana Republican Party that sought to have that limitation wiped away too. And the Supreme Court, without even briefing or argument, affirmed the lower court. So that's still safe. And disclosure laws. Although the Supreme Court has knocked down, one expenditure limit after another, disclosure laws are still fully constitutional, can still fully be enforced, and frankly are still important. Now, there's more work to be done, in all three of these areas. There is still in place laws that provide that if there is coordination between a candidate or a candidate's committee and an outside group, whether it's the political party or some third-party PAC or something like that, if there's actual coordination in the way that the independent group is spending its money, that is deemed a contribution to the candidate and subject to overall contribution limits. The Federal Election Commission, which is the biggest joke of a regulatory agency in the imagination of mankind, has, I mean, if there were ever a regulatory agency that was more incapable of regulating both structurally and, I mean, for all sorts of, they have no enforcement powers, and it is a commission that is composed of an equal number of Republicans and Democrats. It's hard to imagine how you could create something that was more pathetic than the Federal Election Commission. But they have, you know, following the Supreme Court's lead, they have loosened and loosened and loosened the requirements for what constitutes coordination. But there is every opportunity, either in state legislatures and in the Congress, to strengthen that, and there are pending bills in the United States Congress to do that. And that's an area that the Supreme Court has left alone and that has a lot of promise. There is a bill that was introduced by Chuck Schumer last year. It's going to be reintroduced by Senator Udall this year, called the We the People Act, which, you know, maybe I'll have time to explain a little bit, but has a provision that basically gets rid of these single candidate super PACs where some ostensibly independent group is created to which unlimited, undisclosed contributions can be made, and then it's run by the former legislative director of the just former legislative director of the candidate that that PAC is going to be supporting. And obviously there is de facto coordination going on when you have somebody who has just left the candidate's staff and is running this, quote, independent citizens, you know, group supporting him. So there are real opportunities to strengthen existing coordination prohibitions. There are many, many opportunities to strengthen both at the national level and at the state level, although Maine is in the lead here, disclosure laws and disclosure requirements. One bill that was proposed in the Senate last term and was part of Senator Schumer's omnibus bill proposed by Senator King was a requirement that any contribution of $1,000 or more be publicly disclosed within 24 hours, which would be a lot better than the sort of periodic, somehow, sometime, maybe disclosure obligations that currently exist. There is the prospect of a constitutional amendment to popularly overrule Citizens United, however you conceive of that. And I certainly want to give a shout out, there was one earlier, to American Promise, which is a nonprofit and a co-sponsor of today's event, which in a very short period of time has done a lot of good and has done a lot to harness the fact that far more than 3/4 of Americans don't think that corporations should be allowed to make political expenditures in candidate elections, don't think that paying money is speech within the meaning of the First Amendment, that when our framers were talking about protecting freedom of association and freedom of speech, they were talking about the ability of corporations or super wealthy individuals not ever to open their mouths, but just to donate tens of millions of dollars to influence the way that people think about public affairs issues. And incidentally, to create in the minds of the representatives who were elected a pretty obvious sense of obligation to the interests and will of the people who were contributing these amounts of money. So there are 19 states in one way or another, either by resolution or by legislation or a letter signed by a majority of legislators, or in some states by initiative, have advocated the promulgation of a constitutional amendment to essentially enable the regulation of money in politics in a way that Supreme Court precedent doesn't allow. There are something like 750 state and local municipal and county jurisdictions that have passed resolutions also calling for this. That's very encouraging, and hopefully it will continue. Realistically, this is a long shot, but we're all going to be, indefatigable realists here and idealists here. In order to get the Constitution amended, we need the votes of a supermajority in both houses of Congress, and then we need the legislatures of 3/4 of the states to ratify it. And, the people in the audience I see who I think are probably age compatriots of mine will remember the Equal Rights Amendment, which not only made it through both houses of Congress, but seemed like, I think most of our reactions was like, what, that isn't the law already? But somehow never managed to get 3/4, demonstrates just how challenging it's going to be to get a constitutional amendment. You don't always need to have a constitutional amendment in order to have a big effect in the minds of legislators and judges and justices, when they are all ultimately responsible and responsive to popular will. And when they feel the public sentiment breathing down their throats, and there's a real prospect of a constitutional amendment here, when enough momentum builds, we may be able to achieve those objectives in a different way. So, continuing to support these efforts to amend the Constitution to, quote, overrule Citizens United and the body of Supreme Court cases that it stands for is very worthwhile and very important. Now, what we don't want, what we can't want, is the alternative means of amending the Constitution. In Article 5 of the Constitution, there is a provision which has never been implemented for the calling of a constitutional convention. And if, I believe it's 3/4 of the states resolve to call a constitutional convention, the Constitution provides that the House and the Senate shall provide for the convening of a constitutional convention. Now, why do you say I'm saying we need to amend the Constitution if we can't figure out another way to get rid of this line of Supreme Court precedent, but not a constitutional convention? We've never had one since the Constitutional Convention that preceded the Constitution, that is the one that produced our Constitution in Philadelphia. But it's generally understood that once a constitutional convention is called, there is no limit to the number of provisions in our Constitution that can be amended. So even having states all say, we want a constitutional amendment just for the purpose of addressing money in politics, once convened, that convention can address the Second Amendment, the Fifth Amendment, the 14th Amendment, Article 1, Article 2, Article 3, and guess who gets to decide on a state-by-state basis who the state representatives are to the Constitutional Convention? It is the state legislators who will pick the representatives. So as much as we need a constitutional amendment to restore the people's ability to restrain the expenditure of money and undisclosed, unrestrained money in candidate elections, we desperately do not need a constitutional convention, and we are very close to having one. There are something like 29 states at some time or another over the past 30 years, have passed resolutions calling for a constitutional convention, either to have a balanced budget or to enact an equal rights amendment to the Constitution, or to get money out of candidate politics. And, you know, I think we only need something like 37 states do it, there will be a constitutional convention. And as passionate as I am in restoring a meaningful system of regulating essentially who pays for candidate elections and who can create obligated office holders, I'm even more passionate that we do not want a constitutional convention. There are other things, you know, other areas in which legislation, you know, it seems like it's potentially fruitful. One is there is an absolute prohibition, and nobody has suggested that it's unconstitutional, against foreign financing of candidate elections in the United States, and yet we don't have terribly effective means of protecting against that. I don't know to what extent they're true, but there have been any number of investigative journalists writing reports about the solicitation that our current president made of foreign contributions to support his candidacy. And in particular, there is the issue of how does the prohibition against foreign money in U.S. elections play in a world in which corporations can make unlimited expenditures in U.S. elections? I mean, who owns the corporations? Where are the corporations governed? There have been efforts in, I think, the Connecticut legislature and the Massachusetts legislature are considering legislation to require disclosure by corporations that make political expenditures as to the percentage of foreign ownership of the corporations, and perhaps to name the largest shareholders of the corporation. Ellen Weintraub, who is the chair of the aforementioned derided Federal Election Commission, has suggested that the Federal Election Commission should propose rules to this effect, which I can guarantee you, beyond a shadow of a doubt, will go nowhere. But this is another area in which concerned citizens can press their elected representatives to do something and shine a degree of sunshine on the source and ownership of the corporate money that's coming into candidate elections. So that's money. Districting. This isn't a huge issue in Maine because you have every bit of 2 districts. And I know that in the past there has been some interest and activity on exactly where the lines between District 1 and District 2 are drawn. But this is not the epicenter of gerrymandering in the country. Gerrymandering you probably have all heard of. It's a term that was born when Eldridge Gerry, who was an early patriot but a Massachusetts legislator who wanted to be, quote, sure that he would be returned by the citizens, had a district drawn that in contemporary times was referred to as resembling a salamander. And hence the term gerrymander refers to a practice by existing legislators following the decennial census in which district lines are drawn not in a way to provide the most cohesive, consistent, logical districts of people living in proximity to each other, but to draw districts in a way that either disenfranchise voters based on their political affiliation or their race. Now, there has been a lot, the Supreme Court, the federal courts have been pretty active and pretty resolute in enforcing the prohibition against using race as a basis for drawing legislative districts. And the Supreme Court, just this last term, struck down both the North Carolina redistricting that occurred after the decennial census and Virginia. So it was a very good year for people who were concerned about the process of, this is referred to as, gerrymandering is now referred to as packing and cracking. The idea is if you have an area in which one political party or one racial group is inevitably going to be able to elect its candidate, you try and pack as many more of those kinds of people into the district so there will be less of them in other districts. And with racial gerrymandering, the Supreme Court has enunciated what the principles are and what the test is, and they're enforcing it. I have to say, the more nationally pernicious process is political gerrymandering, where the party in political power in the state legislature will set about drawing the legislative lines, both for state legislative offices and congressional offices. And with the power of big data now and very, very sophisticated geo-mapping systems, can surgically draw lines, like around corners and, cutting through municipalities. So you have a situation that is, for example, the one that is presented in a case that the Supreme Court may announce as early as tomorrow that it's going to hear next term, which is a challenge to the redistricting that occurred in Wisconsin. Wisconsin is a state in which 51% of the population voted for the Democratic candidate in state and national elections. But more than 2/3 of the state Senate and the state House and the congressional delegation are Republicans. And there was a lot of testimony in the case that challenged this about just exactly how this came about. The Republican leadership in the House and Senate hired a law firm and a political consultant and set up shop in the law firm office away from the state legislature grounds with no public disclosure. And even as they started to draw these Republican maximizing districts, would not even allow the Republican incumbent in that district to see it unless he or she signed a non-disclosure secrecy agreement. And it was struck down by a 3-judge district court. The state has asked the Supreme Court to take the case, and the Supreme Court probably will take the case. The problem with political gerrymandering is the Supreme Court has recognized for a long time that it is, as the court said in a case that I argued 3 or 4 years ago, quote, partisan gerrymandering is incompatible with democratic principles. But the Supreme Court has never been able to identify a justiciable test, that is a test that courts can apply to figure out when the natural human instinct to draw lines that might allow an incumbent to keep her or his seat strays into an unconstitutional level of disenfranchisement of the voters of that district. They know, they agree that it's wrong. They agree that it's inconsistent with the principles of our Constitution. But they have been very skeptical that there is actually a test that judges could apply to decide when something is too much and crosses over between natural human inclination and unconstitutional. And there is some, I don't know, optimism may be too strong a word for it, but it is still possible, at least as long as Justice Kennedy is still on the court, that the court may actually find a case in which it can articulate standards by which the party in power, whether it's the Democrats in Maryland or California, or the Republicans in Arizona or Wisconsin, can jigger election voting districts so that there really is no real contest in the general election. I mean, over 90% of existing House members in recent decades have been reelected. That is not the result of natural selection. And It's a really, really, really important thing to get right in the country, because you have a situation, and it's a situation now, I mean, where the only threat to an incumbent legislator is, oh, here comes John. The only threat to an incumbent legislator is getting primaried. So I don't know how many of you heard this, but there was on the Fresh Air radio show this week, there was an interview with Joe Biden. And he was talking about when Merrick Garland was nominated. And, you know, Biden has, from all his time in the Senate, has lots and lots of friends on both sides of the aisle. And he was explaining to Terry Gross, he made calls to 14 Republican senators to say, look, this guy is so qualified. He is as conservative a jurist as you are ever going to get a Democrat to nominate. The country needs this. This is the right thing. And what he said is, he said to a person, every single one of them said, we know what we're doing is wrong. We know that he should be confirmed. We wish we could do something about it. But if I step out of line away from my party leadership and say that Merrick Garland should be confirmed, some group is going to put up $5 or $10 million against me in my primary election, and I'll be defeated. Now, we can have a debate. I don't think it would be much of a debate in this group about whether that may well be true, but you were put in this job to do the right thing, not to make sure that you keep getting elected. And if it turns out that you are not elected because you did the right thing, that's even more of a right thing to do. But that is the world in which we live. Now, I will say that there is another way to skin this cat, and it was reflected in a case that I argued in the Supreme Court 3 or 4 years ago, called the State of Arizona Legislature versus the Arizona Independent Redistricting Commission. And John, I'll sit down as soon as I finish this and leave the rest of the stuff for the questions. So the people of Arizona, when they entered when they were admitted as a state, insisted on having a provision in their constitution that the legislative power of the state of Arizona belongs to the people of Arizona, and that the people, although they had a bicameral legislature like all other states, nonetheless retained the power to enact laws and amend the Constitution, which is a difference between, the latter is one difference between Maine and Arizona, as you all now know. And the people of Arizona got sick and tired of the state legislature gerrymandering districts. And there were many, for decades, that no districting plan enacted by the Arizona legislature was ever put into effect because the federal courts kept striking them down as inconsistent with the guarantee of one person, one vote, or racial gerrymandering or things like that. And so an initiative was put on the ballot, and the citizens of Arizona amended their constitution to provide that after every decennial census, districting would be done by an independent commission that would be composed of 2 members of one of the major parties, 2 members of the other major party, chaired by an independent, somebody who had not been registered or active with any political party for 10 years, and that those people would be chosen by the State Commission on Judicial Appointments. And so they did it. And the independent commission drew the district lines, and sure enough, they were sued by the legislature of Arizona as claiming that the independent redistricting commission, tell me when this starts sounding familiar, was taking over a job that the Constitution had allocated to the legislature. And in fact, Article 1, Section 4 of the Constitution says The times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. And their argument to the Supreme Court was, we are the legislature. That is what we are called, the legislature of the state of Arizona, and the people of Arizona have taken away from us something that the federal Constitution guarantees to us. So we had the case, and I argued to the Supreme Court that what the founding fathers meant by legislature, although there was no concept of direct citizen initiative at the time, was not the brick and mortar building in which elected representatives served, but whatever body the people of the state chose to make the laws, and that Arizona, like many other states admitted to the Union during the Progressive era, had chosen to retain the lawmaking power to themselves. And we won 5-4 in an opinion by Justice Kennedy, who as a Californian was very familiar with and very fond of citizen initiatives. So this is a means by which states can themselves choose to draw their district lines. And there is also another intriguing possibility, because the next sentence in Article 1, Section 4 says, but the Congress may at any time by law make or alter such regulations except as to the places of choosing senators. So it is within Congress's power, and it is in fact a provision of the We the People Act that was introduced last legislative session and will be introduced in this legislative session, for Congress to direct that, to require each state to draw its federal district lines by an independent commission to be chosen by the voters of the state. So, I mean, we can all handicap the likelihood that the brave and courageous members of the House and Senate will, in fact, impose that rather novel governance mechanism on their states, but we can certainly encourage them to do so. So I'm not going to address either voting access or the threat to the integrity of our voting systems as laid bare most recently in the infamous Russia probe. But if there's time, maybe we can discuss it in the question and answer period.
Let's show our appreciation. Take a seat in one of the chairs and forget. Thank you very much for that. And now we're going to kind of shift gears slightly and have a little bit more of a panel discussion here and start to engage with all of you with some questions. I'm going to introduce two folks who, first, before I give you a formal introduction, I just want to say how much I appreciate working with them and what lovely people they are, and a great part of the democracy effort here in Maine. First is Anna Keller. Anna joined MCCE in August 2014. She grew up in Maine and has experience in grassroots organizing and local political campaigns, including running herself as a clean election candidate for the Maine state legislature. She has a bachelor's degree in political science from Yale, master's in conflict studies from the London School of Economics, and she has experience with democracy and anti-corruption campaigns in Eastern Europe and Central Asia, a background which reinforces her commitment to preserving and strengthening Maine's first-in-the-nation clean elections program. So, Anna Keller. Wow. Jill Ward is entering her second term as president of the League of Women Voters of Maine after joining the League 8 years ago. At the League, Jill has been deeply involved in nearly every crucial democracy-related reform effort in Maine in the last decade. She is a nonprofit consultant, and her latest project is working with the newly established Center for Juvenile Policy and Law. She's educated at the University of Pennsylvania and Georgetown University Law Center. Jill has always had a strong interest in civic life and public service. She previously worked in the U.S. Senate for Senators Paul Sarbanes and George Mitchell. Jill, welcome. So, are the microphones on? Okay. So, We will have some time for questions from everybody here, but let me just start out by noting that Justice Louis Brandeis in 1932 said, which many of you are familiar with, the concept that the states are the laboratories of democracy. And this is primarily for Anna and Jill to start out with. Does this still hold true? How has Maine been leading on reclaiming our democracy, and why do you think that is? Do either of you like to start, Anna?
Sure, and I'll stick to the campaign finance part of that and let Jill speak to some of the other aspects of how Maine's led on democracy. But when it comes to getting money out of politics, Maine has been leading since at least the mid-90s with our citizen initiative in 1996 that established the Clean Election Act, and the first candidates ran under that in 2000. We've had strong participation from both Democrats and Republicans, independents, other parties, for people being able to run without being dependent on raising big money, letting more people be in our representative democracy. And when we faced the problems with Supreme Court decisions that rolled back the ability for candidates to run and be competitive, Maine went back to the ballot. I know many of you collected signatures at the polls or made phone calls, had house parties, were really the citizens that made that citizen initiative possible. And in 2015, we passed with 55% question 1 that strengthened Maine's clean election system. And since then, we've seen that start to work again. We had a 10% increase in clean elections candidates in 2016. Up to 64% of the current legislature used clean elections when they ran. What we've seen since is that it's not enough to just pass the law. It has to be implemented. It has to be defended. We have to keep looking for the places where it isn't working as well as it could be and plugging those cracks and trying new ideas. So in the current legislature, we have been making sure that there's enough funding for clean elections, including for candidates for governor in the next 2018 election. We've had a couple candidates declare that they want to run as clean elections candidates for governor. So as you know, we still don't have a state budget, and clean elections is part of that fight. We've been lighting up the phones to make sure that we are in that mix. But we've also been working on a couple aspects of private fundraising, some of those areas that Seth mentioned where there are places where we can have stronger regulations, including banning contributions from lobbyists, banning leadership PACs, that let legislators have their own PAC. So there's lots of work that can be done in Maine that is being done to make our elections here more responsive to the people.
Jill, do you want to add to that? What is there beyond campaign finance in particular?
So when we had talked about this question, my two answers were, we show up is why we lead. I mean, Maine has one of the best voter turnout records of any state. We fight with Minnesota on a regular basis for having the highest turnout. And when I went back and looked it up, since the 1960s, we've exceeded the national average by at least 10% every time. So I think one of the reasons we lead is we are a civically engaged people. It is part of our culture. It is part of who we are. And our policies, number two, I think reflect that value of civic engagement, of showing up, of wanting our processes to represent ourselves and our voices. And, we had no excuse absentee ballots very early, and we had same-day voter registration before a lot of other states implemented the policy, and so I did a little bit of research. And one thing that I think, at least I did not know, but it was enacted by a Republican-controlled legislature in the 1970s, same-day voter registration. There was a court challenge that had, I think you had to register, it was almost like 6 months, I think, before Election Day. You had to be registered to vote to be eligible, and that was challenged. And the legislature said, well, why are we making people, why can't they just register right up until the time of Election Day and be able to vote, So I think we have this history of very pragmatic solutions to these problems. We have a history of them being bipartisan, of problem solving in this way. I think same-day voter registration is a good example. I think clean elections is a good example. And I think today, at the League, we're also fighting against things like voter ID and Seth, you didn't get into some of this, but I assume that that was part two. We've been fighting those battles here too, and have had good citizen engagement, and they've been bipartisan fights as well. So I think we just have that in our DNA here in the state, and I think we'll talk a little bit more about ranked choice voting, which at the moment is embroiled in a little bit of a partisan situation post the Supreme Court advisory opinion. But those of you who engaged in that citizen initiative last fall know that that was very bipartisan. Democrats, independents, Greens, Republicans were all very supportive of moving to a system that was more reflective of the will of the people. So I think we just have a really strong culture and history of civic engagement that's reflected in our voter turnout and in the policies we enact around elections.
So in a second, we'll get to some audience questions, but I just want to ask another question first. What do you see to be the promise of ranked choice voting to help address some of the disaffection and cynicism and some of the concerns about the strength of our democracy?
Well, I know at the League, we initiated a study looking at election systems back in 2007. The study started in 2008, and we came to the conclusion to endorse the policy in 2011 because in addition to it being more representative of a majority of the will of the people, because it incentivizes candidates to talk beyond their base, we think it has real promise to get at some of the negative campaigning that you see. If you want somebody's second choice, you can't completely trash every other candidate. You have to actually engage in more substantive, policy-oriented dialogue about what you want for the constituency that you want to represent. So we think it has a lot of promise in that respect. And the studies so far on voter turnout have been mixed, but we do think it also, if you hit at that civility issue, you're going to kind of get people more interested, feeling more empowered about turning up to vote, and that their vote is actually going to be an important part of the process.
And I first became interested in the policy because I had had the experience that I know many, if not all of you have had, of having to cast a strategic ballot when there was one candidate I really didn't like, and I had to try to sit down and look at the polls. I was going to have to vote absentee a month ahead, so I really tried to look at the polls and figure out which candidate had a better chance of winning, and then I guessed wrong because I was a month ahead and I had to look at the wrong polls, and the polls had changed, and that just made me feel like this isn't the way voting is supposed to be. And I think it really does discourage people from going to vote, from feeling like their vote matters, from feeling like they're being represented when that's what voting looks like.
So I have one more question. I'm going to start with Seth on this one. And I'm sure that everybody is, we're all loyal Mainers, but we're also concerned about the national picture. And I want to talk briefly, kind of zoom back a little bit and ask about the big picture here. We have a profound partisan divide nationally. We have a lot of suspicion between different political groups. We've got the emergence of fake news and questions of how confident we can be about the sources of information we have, and we have unprecedented distrust of our major public institutions. On the other hand, we've been through challenges before in this country. How serious is the situation? Will we still have a thriving democracy in 20 years, and what can we do to make a difference in that answer?
Well, this may test my supposed reputation as an indefatigable idealist. I am really worried. I heard somebody say on some talk show that a political scientist that, really for one of the first times in our country, maybe it's the first time since the Civil War or Reconstruction, Americans don't seem to like each other. And I don't think that's true on a person-to-person level, but I think that our systems, our social systems are driven to this through a number of processes, one of which is the sort of, the internet and the sort of the bespoken nature of news now, where there are so many ways to get your news, you just choose whichever blog or news outlet or I don't even know what but some source where you hear what confirms what you already think, and you're sort of getting tailor-made avenues of information and dialogue. But in our political system, and that's why I'm so passionate about what have been talking about, is we have a political system now that is a system of representative democracy, which is being driven to this kind of echo chamber by the fact that we have gerrymandered districts, number one, so that if you are running for election, or if you're running for re-election in a district in which you know that it's almost certain you're not going to lose in the general election, whether you're a Democrat being challenged on the left or a Republican being challenged on the right, that's your fight. And you are driven to a, quote, base which is more extreme than the general population that you're representing. Whereas if you had a district in which in which it was beneficial from the beginning of the declaration of your candidacy until election day to run with an eye toward the sensibilities of people across the spectrum, or at least in the middle, you would have representatives in Congress who didn't have the reaction that Senator Biden, that Vice President Biden reported from his colleagues, which is, we know we are doing the wrong thing. We're ashamed of what we're doing. But if we do it, our base is going to not like us. And when you marry that up with the ability of extremely wealthy individuals or corporations or associations, but very large accumulations of wealth to come in and fund those things, either that or hold the sword of Damocles over the legislator's head, all of the institutional or incentives are towards atomization. There's just like, as much as we'd like to talk across the aisle, maybe we're going to have a Republican-Democratic baseball game, but we aren't going to be talking to A, we're not going to be on the same team, and B, we are not going to be talking to each other outside the game. The deck is stacked, and that's why it's so important to after all, we're in a system in which, the very first words of the Constitution, we the people, the sovereignty in the United States belongs to the people. And the representatives are this is what Republican democracy is. We the people can't sit around all day and try and reach consensus about every single thing that government needs to do. We have to elect people to act in our steads. And if the people we elect are not interested in the mainstream opinion about what they should be doing, the system, the very fundamental of the system works, and it's having the effect of driving, or in addition to the internet and bespoke news sources, it's having the effect of driving people away, because you're getting political figures saying things on both sides that they don't necessarily really believe, but they feel they need to say in order to preserve what they view as their livelihood, but really is a public trust.
I'd be interested to hear your reflections on that question as well. We can kind of incorporate that into the questions that we get going forward. So I think Dash and Sarah, we have microphones in each aisle. So if you'd like to ask a question to the panel, I'd be very grateful if we'd keep the questions to keep them short and make sure that they're in the form of a question if possible, and we'll get the response from the panel. Well, let's go with Eric here.
I just want to follow up on the end of your question, John, to the panel, which was, or the last question to Seth, which was talk more about what we can do. I'd like to. The problem has been appallingly evident for decades now, although it's a complex problem, it's been appallingly evident. Our fundamental problem is people don't think there's anything they can do about it. So I want to not only know what the solution is, I'm not interested in like what the solution is if you happen to be a Supreme Court justice or if you happen to be a president or a senator. What can people do who are not Supreme Court justices? What can ordinary people, what can we in this room do to address these problems, in particularly the problem of money in politics, influence of big money in politics?
Thank you, Eric. Anna or Jill, you're in the trenches talking with people every day, talking with folks in Augusta.
Yeah, I mean, I have two sort of different from each other answers to that question. One is that what we see does make a difference in a state as small as Maine is that our representatives, so someone in the Maine House of Representatives only represents 8,000 people, maybe 5,000 of them who are active voters. It's a very small number of people, and when they hear from even a few of them, it can make a big difference. We had a state representative last year who changed his vote on clean elections funding, and we went back to him and asked him why he changed his mind. He didn't use clean elections. He wasn't in even a particularly competitive district for re-election, but he said, I had 7 people call me. 7 people never call me about anything. I didn't care about this issue that much, and I figured I might as well change and do what they wanted me to do. So that doesn't work with everyone, but it can work sometimes. And so once we see that, and I know a lot of you have come to lobby with us in Augusta, and realizing how accessible our legislature is in Maine, we can have a voice. The other thing that I would challenge everyone to do is to have a conversation with someone who isn't voting, someone who's checked out of the system right now, and take seriously their concerns about why, whether that's something procedural that we could work on fixing because it's too hard for them to get to the polls on election day or something like that, or because they really feel disenfranchised, particularly people who belong to groups that have never had the same kind of voting rights that we've had. So taking seriously those concerns, because I think we can sometimes feel complacent or feel like how could somebody not vote? Isn't it so obvious and so basic? So taking that seriously and having those conversations is how we can start to bring people in.
Yeah, I mean, I don't have much more to add to that. That's been our experience with the League of Women Voters. I mean, when we are in Augusta and our advocacy group is talking to legislators and trying to get members to call and weigh in, I think Anna's right. I mean, it is an accessible legislature. It does have an impact. I think it's important to get educated about what those issues are. I do think I would also agree with talking to people about what the barriers are, because you learn a lot and you can help them give voice to what they're saying through organizations like ours. And that can be very powerful for people, encouraging those kinds of conversations and bringing that information to an institution that really can try to amplify that on behalf of those individuals.
So I have just one. I don't presume to tell Mainers how they can do things better, since you're already above average, maybe in every respect, but certainly in this respect. The polling shows that 80% of people who are registered to vote across the country do vote. But 1/3 of the people in this country, and I don't know what the percentage here is in Maine, 1/3 of people who are eligible to register aren't registered. And so an obvious and easy way to increase citizen participation at the polls and perhaps in the political process is to get more people registered. Now, there's a national law called Motor Voter, which provides that, that requires states to offer registration opportunities when you register your motor vehicle. But there is also a movement in several states, which has been successful in several states, but as my understanding is not successful in Maine, called automatic voter registration, a little bit successful. There, in which states have done this, and there is actually some, to the extent that there's any possibility of anything passing this Congress, this might pass this Congress. Automatic voter registration, which is a law in many states now that says anytime you interact, any interaction you have with a state agency, whether it's to register your firearm or to drive or to seek benefits or to get a zoning exemption or a waste disposal permit, you will be told that you will be automatically registered to vote in state and national elections unless you opt out. And it's something that seems pretty straightforward and that can be done, and I think will have a tangible incremental effect.
So let me just say that there was legislation in our legislative session to enact an automatic voter registration, and the League worked with several other state partners to advance that, and it is now, the bill got amended, and it is now a study that the Secretary of State's office is looking at. So it's not completely dead. It just, because we have no excuse absentee balloting and same-day voter registration, I think the impact here in Maine will not necessarily be what it would be in Oregon, where you had to register 21 days ahead of time. And
right.
I mean, if people understand, in Maine, if you're an eligible voter, you can vote on Election Day. You can register and vote on Election Day. And even if there seems to be some conflict, you can still cast a challenge ballot. I mean, we make it pretty hard not to, exercise that right. You can do it. But I do think the election administration on the back end and some of the improvements and, quite frankly, the economic efficiencies that can be gained by streamlining and modernizing our system are still there. So I think it's not dead in Maine yet, but it did not pass the way it has in other states this last session.
Another question on this side. Yes, this woman right next to Dash.
So I have to take advantage of Mr. Waxman being here to ask this question because I've wondered about it for the last year. It seems to me that over the last 30 years, the right-wing part of the Republican Party has outplayed everyone else very successfully. And when Judge Garland was nominated to the Supreme Court and did not receive a hearing, I kept wondering, so why is that allowed? It's never happened before. So if the Senate chooses not to offer its advice to the president, why can the president not just sit the Supreme Court justice? It just seemed to me that we folded in an unprecedented situation.
Well, we have an imperfect political system. In some ways, it's imperfect because it was devised by imperfect human beings who are imperfect. And in some ways, it's imperfect because it relies on a political solution to dislocations like this. I think there was a question, and a very well-regarded law professor at the University of Chicago, David Strauss, wrote an op-ed and got a lot of support for the proposition that President Obama could have engaged in a recess appointment of Merrick Garland to the Supreme Court. And there have been justices who've been appointed to the Supreme Court under recess appointments. Now, recess appointments don't last forever, but we didn't really need it to last forever. I think it was sort of debatable. Congress has gotten wise to when you have a Congress that is governed by the political party not of the president. Currently, the Republicans or up until at the time, Republicans trying to govern with a Democratic president. And in particular, Republicans led by Mitch McConnell, who made clear the very day that Barack Obama was inaugurated that the duty of Republicans would be to not allow a single legislative success for the president. They sort of get wise to this recess and essentially don't ever go into recess. Even if there's nobody, even if the lights are off, they're technically not in recess. So it probably would have been constitutionally challenging for the president to assert that he was recess appointing Justice Garland. And, the long-term political solution for this is, if people are really upset, to basically say to the 14 senators that the vice president had talked to and others, you didn't do this, and you're now up for re-election. And we're going to make you pay for that selfish decision. I mean, it was an extraordinary event, frankly, not even to give him a hearing. And particularly extraordinary since, I mean, Merrick Garland is a friend of mine. We went to college together. Our children were in school together. We're friends. We worked in the Justice Department together. And he is he's a much more cautious, careful person than I am, and therefore probably more appropriate to be a Supreme Court justice than me. But he was, I mean, not a single person. I mean, you can be sure that millions of dollars were spent trying to dig up something. I mean, the man is 65 years old. He must have engaged in some arguable indiscretion, impropriety in his life. And the fact that no one could come up with anything that he had ever done in his personal or professional life other than vote with all other justices on the D.C. Circuit to deny rehearing in some case that involved firearms. I can't even remember what it was. Said all you need to know about whether he was qualified to be a Supreme Court justice is an apostasy. But the solution in our system to that apostasy is to make our elected representatives pay for that.
Looking for another question over here. Jeffrey.
I have Sally here. She has to leave in a few minutes, so I want to let her go.
Oh, thank you. I have a question about voter referendums, like the ranked choice voting one last fall, which the voters approved. What's happening in Augusta that these referendums that the voters have voted for are being derailed?
Thank you for that question. Not just ranked choice voting, but a number of initiatives are under some degree of attack in Augusta, and the very question of the power of the citizens to engage in citizen initiatives seems to be on the table up there. What are your thoughts about this part of our democracy in Maine?
Well, I think we are seeing a real power struggle. It's almost like a struggle between two branches of government here, that the legislature does not like that citizens are passing more and more referendums that make them go back and have to figure out how to make it work. And they're usually in something that they voted against in the first place and didn't want to see happen. There used to be more of a sense that, well, voters passed it, we have to live with it, at least until their memory is run out, and then we'll try to, undermine it more subtly later on. And I have been shocked at the willingness of many elected officials to say, yeah, people voted for it, but they didn't know what they were voting for. So I think the only way to counteract that is to be educated citizens in their face saying, yes, hi, I voted for this. I talked to all my neighbors. They did know what they were voting for. This is what we want. And try to hold them accountable to it.
Yeah.
Okay. Another question, this gentleman here.
Thank you. Some of you may know that today is the second round of legislative elections in France. So that means that candidates in races where there wasn't a majority, it goes to the second round and it's a runoff between the top two candidates. So it's not exactly the main ranked choice. So French democracy is far from perfect. They don't have same-day registration, but they do vote on a Sunday. And that just seems like a no-brainer to me. I've lived in France for 25 years. And is there any energy whatsoever in this country or in this state to vote on a day that would likely reduce the challenges that people have to get to the polls?
So Sunday voting or voting holiday, any thoughts on that? It has come up in Maine, and we now have, in some towns in Maine, 45% people who exercise their right to vote, their option to vote by absentee ballot before Election Day. So I think it's, to some extent, that trend sort of reduces that issue a little bit, but it still would possibly increase. Does the League have a position?
The League supports a holiday for voting, but we have not, again, the traction in Maine has not it hasn't been sort of a top-tier issue to be trying to push for, because we have all of these other ways you can access with same-day voter and no excuse absentee. And I think just making sure people know that there really aren't that many barriers when it comes right down to it, if people can plan and you can reach the people who would benefit most from mailing their ballot in ahead of time, or even, you know, is it 3 or 4 days, I think you can up to, so.
How about a question from Jeffrey? Jeff Clements?
Thanks, John, and thanks to the whole panel. And Mr. Waxman, appreciate the shout out to the 28th Amendment and American Promise. I'm Jeff Clements, president of American Promise. I have a quick question on the constitutional concepts, as you would describe them, that amendment should reflect. So you won in McConnell, lost in Citizens United. There's a contest between two constitutional visions. Amendments are simple words but big concepts: equal protection, due process. What are the kinds of words like that you would want in this amendment, whether it's political equality, something else, that would help us understand what we're fighting for, not just what we're fighting against in Citizens United, but what are our rights that we're fighting for in the 28th Amendment as you see it?
So I can't give you an easy answer, which I think you probably anticipated, since American Promise has begun a project called Writing the 28th Amendment that I believe is expected to extend over a period of months, engaging constitutional lawyers and ordinary citizens and legislators to figure out exactly what the language should say. There have been some amendments proposed in the Congress, I know of at least 2 of them, that have different language. And there's no easy answer to what it should say, and I think it's reflected, perhaps best reflected in the fact that most Americans will say they're opposed to the Supreme Court's decision in Citizens United. But if you ask them, what did the Supreme Court decide in Citizens United? I'm not talking about most Americans, I'm talking about most lawyers, even most election lawyers. They will not be able to give an accurate answer to that open-ended question. And what people are referring to is the general sense that a body of Supreme Court law has now built up that has made it difficult, if not impossible, to restrain the influence of corporate and other large accumulations of money being used expressly to influence the outcome of representative elections and thereby create a system of obligated office holders. And on the one hand, people who feel like we need to change this in order to restore democracy or enhance the level of democratic participation that the framers surely envisioned. And we ought to be absolutely clear and unrelenting about this. At the same time, if you ask them, well, how strongly do you feel about the First Amendment, which is the provision of the Constitution that has led a majority of Supreme Court justices to say we can't impose these kinds of restrictions on what they refer to as political expression, I think it requires some very careful thought. I mean, one of the provisions in the proposed 28th Amendment would be, an amendment that basically says that corporations are not people and they don't have constitutional rights. There are a lot of implications about that, and the Supreme Court has never actually said that corporations have First Amendment rights. They have created a rule that has that effect. What they have said is freedom of expression and freedom of association cannot be, those principles cannot be denied on the basis of the person uttering the expression or creating the association. And they haven't exactly said that money is speech. What they've said is that most political expression requires money for its exposition and publication. And in crafting the ideal constitutional amendment, I think is going to involve some serious discussion and understanding the implications of language that is too prescriptive on the one hand or not quite prescriptive enough on the other.
I have one more question back here. Yes.
This is a follow-up to that. Is a constitutional amendment the only way to overturn Citizens United? If with a different court, is there a way to challenge the thinking of that as just being wrong-headed, that this is really giving rich people a double vote because they're already voting their mind and then their corporation is getting to vote again? So is a constitutional amendment the only way to overturn that?
No, the Supreme Court, there is a principle called stare decisis, which is a fancy Latin term for the principle that once something is decided, it should stay decided, right or wrong. But it's not an immutable principle. If it were, Plessy versus Ferguson, which declared in the early 20th century, declared separate but equal, was fully consistent with the Equal Protection Clause, would still be the law, and we'd have black schools and white schools. It's a stare decisis is generally viewed as less strong of a principle when you're talking about explicating what the Constitution means, as opposed to deciding what some act of the legislature means. Because if the Supreme Court or the Supreme Court of Maine says, well, there's a statute and here's what it means, if the legislators basically say, what are they talking about? That's not what it means. We're going to pass it again so that we overrule this decision. That's much harder to do in the constitutional context, as we've discussed here. And so if 5 justices of the Supreme Court become convinced that Citizens United was an erroneous interpretation of the First Amendment, they can say so. And in fact, in Wisconsin Right to Life and Citizens United, the Supreme Court said, well, we decided something in McConnell versus the Federal Election Commission, the case that upheld the Bipartisan Campaign Reform Act, but we made a mistake, and now we're holding otherwise. In Citizens United and Wisconsin Right to Life, it could be done. It takes 5 justices who believe that it was a misinterpretation of the First Amendment to do it. There are 4 justices on the Supreme Court who have already said, both in Citizens United and since then, that they are off on the wrong track, very much off on the wrong track. But there's only one number that counts with the U.S. Supreme Court, and that's the number 5. And you can say that all eyes are on Justice Gorsuch now.
Any thoughts on what to expect? Justice Gorsuch?
Justice Gorsuch, I mean, he has a well-deserved reputation for being a strong, principled conservative, and strong, principled conservatives on the Supreme Court have not are the votes for Citizens United and Wisconsin Right to Life. He doesn't have much of a voting record as a 10th Circuit judge on campaign finance issues, or for that matter on other democracy-related issues like voting rights and registration and things like that. He did issue one concurring opinion in a challenge brought to Colorado's laws that suggested that he thinks that the appropriate standard of scrutiny for contribution limits is what's called strict scrutiny, which is something extremely close to the death knell of any legislation. And heretofore, since 1976, campaign limits as opposed to expenditure limits, that is, giving money directly to candidates, have been tested under a less strict standard of the First Amendment than expenditure limits. And many people have speculated that, he might join Justice Alito and Justice Thomas, who have already written that they think strict scrutiny should apply, which would probably spell the end of even contribution limits, candidate contribution limits. The other, I guess, data point is, I mentioned that in this Louisiana Republican case where a 3-judge district court upheld the soft money prohibition in the BICRA, the Bipartisan Campaign Reform Act, 2 justices dissented from the Supreme Court's affirmance and would have granted review in the case to reconsider that. And Justice Gorsuch was one of the 2 justices. So there's reason to be somewhat concerned for those who, are in favor of reconsidering some of the Supreme Court's more, post-McConnell decisions. But, sooner or later, Justice Gorsuch will speak his mind.
Is there time for one more question?
I don't know. Ask that.
We're all here. Let's take the prerogative of having one more question. This gentleman here, yes. The gentleman in the 3rd row. Yes, sir. Yep.
Far from the mic.
Thanks. So a number of people have said that maybe 80% of Americans would prefer there to not be big money in politics. And I would think that the gerrymandering, that there might be nearly as much support for non-political drawing of districts. It was very interesting what Arizona did, and that's very hopeful because it does. Hopefully the amendment will come through that we've been talking about. But in the meantime, you could imagine that happening state by state. Is there any sense that other states are taking that up?
So Arizona was not even the first state to do it. California was the first one to do it, and California has had an independent redistricting commission. Now, each of the states that have it, they have a somewhat different character. Some of them are independent commissions that make a proposal to the legislature. Some of them are independent commissions that are empowered to draw district lines if the legislature can't agree, or if the legislature's plan is struck down by a court. So California has one, Oregon I think has one, I believe Washington has one. You'll see a theme here. And Arizona, which has traditionally been a very politically conservative state, has been, I'm using the small p, progressive, not liberal. Has been very forward-leaning in campaign finance restrictions. They lead the nation in the number of progressive state laws that have been struck down as unconstitutional by the Supreme Court. They had a public financing system that was very robust and, in fact, provided that if your non-publicly financed opponent raised, through large contributions, more money than you could max out on, that you could match dollar for dollar the overage to your opponent. And the Supreme Court said the government doesn't have a compelling interest in, quote, leveling the playing field. The Constitution doesn't permit government to equalize the voices. I know this is strange to say or to hear. Doesn't have the Constitution won't allow legislatures to render essentially roughly equivalent the voices of political candidates or participants in the political process. The only justification that government has for restraining the expenditure of money is corruption. And the definition of corruption has gone through a metamorphosis that has culminated in Citizens United, where originally corruption was understood to include the appearance of a system in which office holders would feel obligated to those that had accumulated large amounts of money to enable their election. That the Supreme Court has now said that the only form of corruption that is recognized is quid pro quo corruption, which is, or the appearance of quid pro quo corruption, whatever that means. And quid pro quo corruption is proof that I gave you money for you to pass this law, and then you voted for that law because I gave you this money. And unsurprisingly, evidence of that conduct doesn't fall off the back of the turnip truck. It's pretty hard to find. And on those few occasions when it occurs, those people tend to go to prison. And so, you know, Arizona has tried very, very hard to enact a system, enact progressive reforms. I think in large part because there is this strong tradition of citizen initiative. And, you know, just like as Sarah was explaining, you know, state legislators are just like, wait a minute, hold on a second, like we were elected to pass laws and now they're passing laws? It's like only, like, how many people can pass laws here? We're the experts at passing laws. They are not the experts at passing laws. And there is this sort of tension. And so what you find in the redistricting, in the district drawing areas, is this should be a nonpartisan issue, but it turns out to be a highly partisan issue that the minority party feels civically passionate about. So as I said, you know, the Republicans in Illinois and Maryland, you know, feel like it is the central tenet of good responsive government to have the district lines drawn by an independent commission. And because, you know, the states are heavily Democratic, and that's the only way that they're going to have these things drawn. And there are heavily Republican states where, you know, Democratic politicians feel terribly strongly that it's an important civic mandate to do this in a good government way. I'm in the process, in anticipating that the Supreme Court is going to grant review in this Wisconsin redistricting challenge. I have volunteered to write an amicus brief for members of Congress, sitting and former members of Congress, as a friend of the court. And unsurprisingly, the first place to go to find people who are willing to sign up are the, you know, few Republicans from the Maryland delegation and Democrats from the Nevada delegation or the Alabama delegation. I mean, the people where there's a strong local interest in having it done will be most happy to sign on. It'll be interesting to see how many signatories I can get from elected members of Congress from the majority party.
Well, I have a sense that Andy's flashing the red light at me, so let's say thank you to Jill and Anna and Seth Waxman.
Thank you so much. Our founding fathers would indeed be proud of this conversation that we're having on this Father's Day, and we know you all have maybe more Father's Day plans after this. I just wanted, you've come a long way, Seth, to be here on the rocky Maine coast, so we wanted to offer you a small token of our appreciation. This is The Lobster Coast. It's by one of my favorite authors, Maine-based Colin Woodard. And if you're wondering why these people in Maine are above average, maybe even exceptional, perhaps this book will provide you with some answers. More shellfish? Yeah, more shellfish, yes. So again, thank you so much, Jill, Anna, Seth, and John, for this. I started my talk, started with comments about me at 13 years old and how my life was affected and how I went to go on and create social change from there that led me here. But as you all leave tonight, I ask you to think about remembering who you were at 13. And since becoming 13, how has our democracy responded or not responded to some of the challenges that you saw as a 13-year-old, maybe another 13 or a few decades later? So as you think about that, and that question that Mike Vlader asked me after that, which was why Maine, I'm increasingly convinced that what we have in Maine is not dissimilar from other states, which are exceptional people that want a better tomorrow. And you all have been the fuel to our effort here in Maine, how we've led the nation. And it's through people stepping up and playing the role of citizen, by volunteering, by donating, by knocking on doors, by having conversations around the table. So, to use another fancy Latin phrase, and a prop, On the back of a dollar bill, in the national seal, it says Novus Ordo Seclorum. I think I might have botched that, but it means a new order for the ages. And that's what our founding fathers set out for us, something different, a republic, where all of us are more powerful when we are combined and have a unified voice, or at least a process by which all of our voices come to the table around important policy debate that affects our lives. So as you leave here today, our interns and staffers, will have volunteer envelopes that you can make a donation, either a one-time donation or you can make a recurring donation for as little as $5 a month. I personally sign up for $25. And I think the most honorable thing that we could do is to recommit on this Founding Fathers Day to those ideals that we had. So please, as you leave, take a donation envelope, consider making a gift of your personal treasure, and if that's not possible, please consider donating some time so that we can pass down to that next generation an even better democracy, a more perfect nation for the ages. Thank you so much. And that's a wrap.